And we are here on the plaintiff's motion for a temporary order. We have both parties present in the virtual courtroom, as well as attorney Sue-Ann Watt-Stay on behalf of the plaintiff. Ms. Watt-Stay.
Thank you, Your Honor. I know the court's probably had an opportunity to review the motion that we filed. I don't have a lot to add to the motion. What we have here is a somewhat complicated case. I think the court's probably aware that there had been a previous filing. The parties did reconcile. In that situation, the defendant was pregnant. They didn't know that when the original filing occurred. So they've been trying to make it work. We're now essentially 6 years later, and we're still experiencing some of the same issues. My client and the children are currently residing with his parents, and they have been since July of 2025. School has begun, obviously, again. We're at the end of September. It would be great for the kids to be back in the home, which is in the school district. Right now, it's a little bit difficult not difficult, he's managing it, but it would be easier for the kids, especially their daughter, who is 14. She's involved in activities, etc. And it would be easier for them to be back in the home. Some of the same concerns exist now that existed at the time that we filed this initially. So I can go into more detail if the court would like, but at this point in time, we are requesting a temporary order that awards my client physical custody of the kids. We're happy to discuss an appropriate parenting time plan, and that he and the children be allowed back into the marital home with the defendant finding somewhere else to reside while this is pending.
Right. And did we have a temporary order in the prior filing?
We did. We had filed an ex parte order at that point in time. And so I believe that was attached to our filing, the ex parte order that was entered. It awarded my client physical custody of the children. The defendant was to receive supervised parenting time. She was required at that point in time to submit to a psychological evaluation. To the best of my knowledge, that never occurred, or at least we never saw anything from that before the reconciliation occurred. So, but that was, we had filed an ex parte order, and then we had the hearing a couple weeks after, and then that order was amended slightly just to address some of the psychological evaluation issues.
And I do see it. It was at the tail end of your exhibit.
Okay.
So
Sorry.
thank you very much. But no, that's fine. I mean, thank you for pointing that out. I did read the motion. I'm not sure that I saw the exhibits.
No, that's okay.
All right. And Ms. Crawford, do you have anything you'd like to say about the motion?
Yes, I do. I would like to file for proof of service being served for this hearing today. I have some evidence that I was not served with an adequate amount of time to prepare for custody response, financial, forensics, accounting assistance. So I do also have a motion to enter for forensic accounting assistance regarding the assets and property in the home.
But that motion was not noticed up for today.
For delegation for all of the divorce concerns mentioned in this meeting, in this hearing, is the first I've heard of. So I would like to request proper serving proof of service process.
All right. Ms. Watt-Stay, do you want to respond to that?
Yes, Ms. Crawford was served personally by process server George Noble. I can get documentation. I'm sure we have it. I can email my assistant quickly. I'm assuming the proof of service was already filed with the court.
Let me just check with Ms. Van Noller.
Okay.
Check the court record.
Oh, I'm sorry. I actually do have it in front of me too. So.
Okay.
But it was filed.
Can you just for the record state the date and the time?
Yep, she was served on Thursday, September 18th at the marital residence at 12:45 p.m. And that was by George Noble, who is a 62B district court officer.
All right. Thank you.
Our court record has the last docket entry being 9/22/2025, saying the summons was returned, served on 9/18/25.
All right, so that also confirms. All right, based on that, I'll find that proper notice was provided for this motion. I will take judicial notice of the prior case as well as the orders that were entered in that case. And I will award temporary sole legal and physical custody of the minor children to Mr. Crawford, that Ms. Crawford have reasonable supervised parenting time with the minor children. Award Mr. Crawford immediate exclusive use and possession of the marital residence for himself and the children, and order that that Ms. Crawford submit to a psychological assessment, and follow any recommendations from that assessment. Provide a copy of that to Ms. Stay as well as to the court. And is there anything further?
I don't believe so, Your Honor. As far as the immediate possession, I'm going to prepare an order. If I email that over to your clerk, is that something that we can get signed today, just in case we need
Yes.
it in
And
order?
I should indicate that I will provide for seven days. as
7 days?
opposed to-
Okay,
Yes, I think that's appropriate.
okay. I understand and I believe that's reasonable.
Okay.
Okay, I will go ahead and prepare that order and get it over to the court.
All right. Thank you. We're adjourned.
Thank
Thank
you.
you.
This is Boyer versus Boyer. We are here on Ms. Boyer's objection to the referee recommended order that was entered in this matter. I have read the motion to object. There's also a motion to enforce the judgment that the defendant filed. We will take the plaintiff's motion to object first. And I did read that motion. Ms. Boyer, anything else you'd like to say?
I'm just here because the defendant is refusing to let my daughter participate in sports and activities that fall on his parenting time.
As I said, I read your motion, so I'm aware of that. That's why I was asking, is there anything else you'd like to say?
No, not at this time.
Okay. All right. And Ms. Van Dyken, any response?
We'll stand in our response and the referee's decision, Your Honor. Thank you.
All right, thank you. The de novo court rule is very clear, that first of all, that the and this is MCR. Sorry, this is the de novo court rule regarding referee recommended orders that are objected to, and it's very specific. That the court may prohibit a party from presenting evidence on findings of fact to which no objection was filed. From the plaintiff's motion to object, it doesn't appear to the court that there's any additional evidence or new evidence that was not available at the time of the referee hearing. The court has reviewed the transcript and finds that the referee was correct in her rulings pursuant to case law regarding a motion to change essentially custody, and the fact that the plaintiff did not meet her burden of proof in order to even have the court look at that. Now we will move on to the motion to enforce the judgment. Ms. Van Dyken.
Thank you, Your Honor. It's pretty clear what we're asking for, that the plaintiff is continuing to receive funds for daycare that she doesn't utilize. And we're asking for that to cease immediately. And my client would like reimbursement for the last, I believe it's been a year that he's been paying.
Okay, let me stop you and let me ask her about that. Ms. Boyer, do you object to that?
My father is taking care of her in the morning and after school currently because of my work schedule. So he is the one that has been watching her and taking care of her. But I have no objection to ending the daycare if that's what he wants.
All right. And what about the past year that you've been receiving money for daycare costs that you allegedly haven't been expending?
She's been being watched by my dad.
Okay, then I will grant the defendant's motion regarding that. Ms. Van Dyken? Please
Thank you.
continue.
Thank you, Your Honor. We then had a concern with regard to a cell phone for the 9-year-old that it's not being used appropriately. I don't know what a 9-year-old uses the phone appropriately, but it's being utilized to interrupt and disrupt defendant's parenting time. It's used to track the child during his parenting time. That just needs to cease. These parties have a legal and joint physical custody, or he has parenting time with his child. It shouldn't be interrupted by a cell phone, nor should he be tracked with what he's doing with his child during his parenting time. So we simply ask that the cell phone remain with the plaintiff during defendant's parenting time.
All right, Ms. Boyer, any objection to that?
First, I don't track my daughter with the cell phone. He constantly is FaceTiming and talking to her at my house. And she has stated that he will not allow her to call at their house because they are too busy. And the one time I tried to reach out on my account first was simply to ask for her opinion on which school backpack. So I had requested if he could have her call me when she was available for that. Otherwise, I never initiated contact over there. Their reasoning behind it is crazy to me, but I just ask that if it's fair that if I'm not allowed to contact her on it at his house, then he's not allowed to contact her on it at my house.
Ms. Van Dyken?
I see no problem with that, Your Honor. If parties want to reach out to the other parent to have some communication, I think that's the most appropriate. So the cell
I would
phone-
agree. I would agree. At the age of this child, court has questions about this child having a cell phone in the first place, but I do think it would be mutual if there's a restriction. So the court will order that.
And finally, Your Honor, we're just looking for an admonishment with regard to the joint legal custody status. It's apparent that Ms. Boyer wants the child involved in a number of activities, and then has unilaterally changed the dentist. There is a joint legal custody order. They need to communicate, and we're just looking for admonishment from Ms. Boyer.
Do these parties have Our Family Wizard or something like that?
I don't believe so, Your Honor.
Okay.
No.
Okay. I think that perhaps that would be helpful in this case. And is Our Family Wizard okay? Because I do have a template order for that, that the parties would only communicate through that app. And the nice thing about it is it does provide a record of what's been said between the parents. It also provides a place to put the child's calendar, to have discussions about things like extracurricular activities, but provide a record of what those discussions were. And so, Ms. Boyer, are you willing to use something like that?
Absolutely.
Okay. Ms. Van Dyken, is Our Family Wizard okay, or do you have another app that you would?
No, Our Family Wizard is fine, Your Honor, and I do have that template.
Okay, great.
Okay.
All right. So I will just enter that order, that the parties use Our Family Wizard for communication. And Ms. Boyer, you do have a joint legal custody situation, and you cannot make any major decisions such as changing healthcare provider, or even extracurricular activities without consulting with Mr. Boyer. If the two of you can't come to an agreement, then unfortunately you'll have to come to court and have the court resolve it. But you can't make these decisions on your own. All right. Anything further?
No, Your Honor, I can prepare the order.
All right. Thank you.
Thank you.
We're adjourned.
This is a turning point that tests what counts as truth in family.
Ms. McCann, we're here on the plaintiff, Ms. McCann's objection to the referee recommended order that was entered by this court. And I'll just indicate to both counsel that I have read the motion, the response, and the briefs.
Thank you, Your Honor.
Ms. Drake.
Your Honor, we are simply requesting a de novo review by the court to allow the parties to present some live testimony as well as some additional facts that have occurred that continue to support my client's position that parenting time and/or custody should be modified. So we are requesting for that de novo review to be scheduled with Your Honor.
All right. At this point, I think you need to make an offer of proof as to what new evidence or new witnesses that you intend to call, and why it was not available.
So I would have my client testify about additional information she has received about disclosures that have been made by the child or children as it relates to continued fear of the defendant, continued physical uses of physical force to discipline, and concerns that she has of the mental health and well-being of the minor children.
So you want to introduce hearsay evidence by the children?
Well, it's going to be information that my client, observations of my client, and I believe some of the hearsay would be categorized as excited utterances or a present state of mind, which would be hearsay exceptions. And in addition, the court did not interview the minor children. So I believe the court needs to interview the minor children in making a final evaluation and determination.
Well, on that issue, because I read most of the transcript. The referee didn't make a specific finding that the parties had agreed that the children should not be interviewed. Is that incorrect?
In the friend of the court interview, they agreed to not have the children interviewed by friend of the court. I requested following the hearing, because it's clear error if they aren't interviewed, if there goes through an evidentiary hearing. I spoke with Mr. Van Elderen. He and I talked about reaching out to the court. I sent that email, CC'd Mr. Van Elderen, and then I was told through the clerk that we didn't request it on the record, and judge was not going to consider, or referee was not going to consider that.
What about the recent case? And I'm sorry, I don't have the name of the case in my head right now, that just came out regarding child interviews. Are you aware of that case?
I'm not aware of that case. No,
Okay,
Your
you
Honor.
might. I'm sorry, I don't remember the name of it. It just came out in the last, say, month. You might want to review that one. Mr. Van Elderen.
Yeah, I obviously stand by the referee. I agree with the referee's analysis and decision. I would stand by my motion and brief. I would object to any hearsay evidence, additional evidence from the minor children. And so obviously she's entitled to a de novo review of of what has already transpired, but I don't believe that there's anything relevant here based on her offer of proof.
All right. Well, the de novo review, I think, is pretty clear that the court can restrict any new any de novo hearing to the record of the referee hearing, as well as the any new evidence that was not available at the referee hearing, provided it's admissible evidence. I will set a evidentiary hearing on this, a limited one. And in the meantime, as I said, I would expect both counsel to review that case regarding interviewing the children that just came out.
That case is Bauer v. Widelich, I think is the name. I can't pronounce it. It's W.
You happen to have the site for Mr. I don't.
It's docket number 345756.
All right.
So this is the one I'm reading the blog.
4...
What? Oh, sorry. 345756. There's a blog on Lisa Speaker's, or there's an article on Lisa Speaker's blog on it from July, right? That's the one you're talking about, right?
Yes,
Jeff?
yes, I am. I guess it's been a little longer than a month.
I'm disassociating with time at this point. I can't believe it's September. It's wild.
Yeah, nobody wants summer to be over with. All right. So as I said, we will set a hearing. I just asked both counsel to review that case and be prepared to let the court know what they think that case means in the context of this case, and also that any motions in limine would need to be filed at least 1 business day prior to the evidentiary hearing, and we will issue a scheduling or a settlement order or whatever, a procedural order that indicates how this is to proceed. And Ms. Vandeler, do you have a date and time for that hearing?
When would we be looking?
Well, I know October is pretty much out. I know we're full. So Do we have anything in November, or we might have to go in December?
We have, November 14th from 2 to 5 p.m.
And we can stop streaming at this point as well.
To close things out, the judge drops a recent legal precedent that could reshape this case. He limits what can be retried, sets strict rules for new evidence, and locks in a date for the next hearing. If you enjoyed watching how these real courtroom moments unfold, don't forget to like the video, subscribe to the channel, and we'll see you in the next one.